Hello, my name is Galina Kordina. I live in Toronto, Ontario. I'm a victim of psychotronic mind control weapons. I filed 3 lawsuits with the Superior Court of Justice in Toronto. The first against the Toronto Police Services for negligence and RCMP for negligence, and 2 of them against doctors, psychiatrists, for medical malpractice negligence because they formed false psychiatric diagnosis after I had reported to them symptoms of mind control attacks. That's why there was an appeal hearing in the Court of Appeal for Ontario on the 15th of December 2009. It was an appeal hearing against the Toronto Police Services and RCMP. I would like to read a paragraph from papers that I prepared for this appeal hearing. Psychotronic weapons attacks and negligence of the police may be proved if Constables Corby and Khan are put on oath and testify microwave hearing in a room of plaintiff in February 2008. I just want to remind that Constables Corby and Khan came to my place, and Constable Corby confessed that he experienced sounds and noises in his head at my place in February 2008. Plaintiff tried to examine Constable Corby for her actions against psychiatrists Drs. DF and Gratze in the Superior Court of Justice. At the first motion, it was said to her to examine Constable Corby orally. She called Constable Corby and asked to set date and time comfortable for him to come to a reporting service and be examined orally before pending motion. He refused to be examined and said that plaintiff should not come to the 33rd Division of the Toronto Police Services with any court documents for him. Plaintiff brought another motion to examine him by means of written questions to the Superior Court of Justice, since there was no way to examine him orally. Unfortunately, it was said to the plaintiff at this motion that information of Constable Corby wasn't relevant to the material issues of these actions against doctors. I disagreed, but it was decision of Master Hawkins. Mr. Squire, a lawyer for the Toronto Police Services Board, said to Master Hawkins this motion against Dr. Gratze on the 19th of May 2009. If plaintiff examines Constable Corby, she will get a proof of the police negligence. Information of Constable Corby is extremely relevant to the material issues of this action. I asked the Court of Appeal to send this case back to the Superior Court of Justice and let me examine Constable Corby. Unfortunately, Justices dismissed this appeal as well and didn't let me examine Constable Corby. The lawyer for the Toronto Police Services, Mr. Squire, was at this appeal hearing. He heard my words, but he didn't say anything. He didn't argue. He didn't tell that this phrase wasn't his. Several days ago, I decided to order a transcript of this motion in the Superior Court of Justice. And when I received, I couldn't find this main phrase of Mr. Squire. Sorry, I experienced false speech which prevents me from talking normally. I apologize for this. I'm absolutely sure that this main phrase was deleted and deleted intentionally. What I found about Constable Corby: would it be unfair for Constable Corby then to have to answer the question? He meant question regarding this microwave hearing. It would be, if Miss Kordina is not willing to limit the use of Constable Corby's answer to this action, the Dr. Gratze action. Because if she is successful in setting aside Justice Pitt's dismissal, she may be able to use whatever answer he gives here to impeach him in some other action. Mr. Squire meant that if Master Hawkins let me examine Constable Corby, I would be able to use whatever answer Constable Corby gives me in some other actions against Toronto Police Services. One more time. Mr. Robin Squire, a lawyer for the Toronto Police Services, said on the 19th of May 2009, if plaintiff examines Constable Corby, she will get a proof of the police negligence. Sorry, I experienced for speech, so maybe some words I couldn't pronounce well. I apologize for this.